when, before the 1935 of the British Indian Constitution Act, which is more or less, is in some provision at least reproduced in the Indian Constitution, the Government of India Act by Parliament, till then the judges held the office in the pleasure of the Queen. That did not deter them, fiercely independent, and being deciding great cases even against the government. In fact, when the centenary of Calcutta High Court was observed, it's written, Sir Harold Derbyshire, I believe, in the centenary volume writes, then we met two persons who have been members of the Privy Council, said the Calcutta High Court is fiercely independent. I mean, these are stories, I am not here to recount them. Therefore, I mean, it's not the mode in which is appointed, but the principles you follow, making a choice of a judge, that is more important than the methodology of appointment. Now, we could have a straitjacket formula. I suppose that would be more harmful than making it good for the judge. Then I had faith, as Mr. Gopal Subramaniam said, personally, if I would permit me to raise my own experience about it. While in Bombay High Court, I had faced with the prospect of the bar agitating against the four of my colleagues in the High Court. They refused stoutly to attend his court, and the entire court remained in turmoil. What I did, of course, without any legal precedent, I suppose, without there being any law about it, I said there will be no vote on that matter. There will be assignment of any business to these judges, but they can come. They are free to sit in the chamber, but not in the courtroom. These are not palliatives. These are drastic measures. This has been placed by certain principles by which one decides. But as you have seen, the conduct of the judges on occasions which arouse our criticism, call for their stringent action. I suppose these should be divergences or should be exceptions. But what would keep the judiciary's independence, their views given without fear or favor of which you take the oath when you become a judge. I mean, these are possible only when there is a certain standard or principle established. I believe, I will recall, Mr. Gopal Subramaniam recalled the Malaya judges who had bowed out to the administration at one time, and which was compared with the Chief Justice of Pakistan, who just retired, Justice Iftaruddin, I believe is the name. I mean, he stoutly denied the military ruler of that country to bow to him and to the dismissal of that order that was made. It was possible for the bar, whatever you may think of Pakistan, it was possible to stall that matter, patently illegal by the administration, to have him on office. Therefore, it has to be a conjoint action of the bench, bar, and general public. The expectations you have of the judges, that is possible when you have, as I indicate, certain ethical standards, not necessarily written rules to behave and to conduct ourselves. In fact, that I believe would be the rule. If I have fed myself, the moral values, your public morals, how you believe, how you work in relation to your duty, in relation to others, that is more important than having rules. Had there been a law epinacia for crime, or for that matter anything, Indian Penal Code enacted in 1860 would have been an answer to the crime that are committed in large and larger numbers. Whereas suppose what is lacking is the values is now despairing, the way we behave, and the carrot stick we sometimes held out, that creates a problem. I mean, you said about Justice A.P. Sen, I had privilege of knowing him. He had come to Calcutta because of some difficulty. We are still a Supreme Court judge, came with a brother judge who was a judge in another High Court of India. They traveled by bus on occasions. Of course, he did not take kindly to us personally, but personally I have a very sweet relation with him. Therefore, this is how one has to, as I remember, one has to behave like normal human being. When you sit in the chair, what is important is, while not like both rajas seated but you have to be a humble person, deciding not necessarily correctly, but objectively and honestly. That's what is expected with us. It's not the correctness, but the impact, dispassionate decision, applying one's mind, that's what does help it. Therefore I'm sure, and what Mr. Subramaniam has said, will make us think that how it is necessary to have value and standard of behavior, which might be required no longer a law which is, as you say, when law is made, you say after all law is also a rule of conduct sanctioned by statute or by the state. What we need is, the value devolution, which is the value which is now being diminished and disappearing. This has been a greater challenge than what. Reminding Mr. Gopal Subramaniam, Veeraswamy's case was not a follower, but then another who was closely related to him faced a prospect of an impeachment without uttering things. Thank you very much. You're asked to say a few words. Thank you very much.
Thank you very much, Your Lordship, for sharing with us these anecdotes and giving us a taste of perhaps how the principle of integrity is better implemented, in fact more wonderfully sharpened when tempered with the ideals of warmth and humility. Ladies and gentlemen, we have amongst us a man who is known in the legal circles for his jurisprudence, especially in human rights. He is a former judge of the Supreme Court of India and the present chairperson of the State Human Rights Commission. Allow me to welcome Justice Sri Ashutosh Kumar to give his observations.
Thank you. Justice Ashutosh Law, the father figure of the judiciary here. It was not only in Calcutta, I think all over India. My very good friend Gopal Subramaniam, one of the star performers of this evening, Mr. Justice Aniruddha Bose, Madam Chakravarti, the head of the department, Madam Mamta Roy, I. Janet, and my friends, ladies and gentlemen. Well, the concept of independence of judiciary, on which you have heard so much from different speakers, I can really add very little to it. But if I may say that this is a concept which is as old as human civilization. It is flowing from the days of the Magna Carta, when it is said that we shall not sell or deny justice to anyone. When we say we shall not sell and deny justice to anyone, that means it presupposes the independence of the judiciary. But the concept of independence of judiciary, it's very easily perceived, but in actual practice, we sometimes find a departure. Lord Denning, about whom you have all heard, in a dissenting judgment in the Court of Appeal, said that there are two kinds of judges. Wait for this. As I am telling you, Lord Denning in a dissenting judgment in the Court of Appeal said there are two kinds of judges. He divided them into bold spirits and timorous souls. If there are this kind of judges everywhere in the world, in the jurisprudence of different worlds. Ashutosh Mukherjee has referred to the community of Derbyshire, Harold Derbyshire, where his lordship said the Calcutta High Court is still independent. And he said so that he let it remain. Not only is it still independent, let it remain. And I hope Calcutta High Court has remained independent. We have judges like Justice Ashutosh Law, now the Calcutta judiciary is represented by Justice Bose and other very eminent judges. But the question is why independence of the judges is such an enduring value, because it is on the judge which is dependent. The entire, if I may say so, the fabric of society. This is why Lord Denny again said that the judge is not a mere mason. He is not to lay one brick upon another. He is an architect. The whole social designing depends on him. But the great jurist Roscoe Pound said that law is a mode of social engineering. Who will do it except the judges? And under our constitution, the judges have been given a very important role. You see, under Article 13, it is very important. 13 says that before the constitution came, there was a set of laws. So that no pre-existing law can continue, violating the mandate of the fundamental rights. And if a new law is made, ignoring the mandate, it will be declared void. Now who can declare a law to be void? Only the judges. Nobody else. The legislature which is making the law will not declare the law void. The executive power does not have the power to declare law void. It is only the judges who can declare. We have all rights under Article 19, right of freedom of speech, right of expression, right of movement. But they are controlled by certain concepts in public nature, in general public interest. That those are reasonable restrictions. Who will say whether the restrictions are reasonable? The judges. So the independence of the judges is very important. In our country, the question of independence of judges came in the public forum twice, very effectively. Once at the time of supersession of 3 eminent judges of the Supreme Court and appointment of a junior judge as Chief Justice of India. At that time, those who were advocating the executive, who had a major say in the appointment of judges, they advanced the theory of committed judiciary. If I may say so, if I remember correctly, if I am wrong, Mr. Subramaniam will correct me. I think Mr. Mohan Kumar Mangal wrote a book on judicial. He gave the concept of introduce the concept of committed judiciary. And he said that the judges must accept the social philosophy of the party in power. That is their doing. To that, there is a book written by him called Judicial Appointment. The great, the great jurist, Palkiwala, also wrote a book called A Judiciary Meant to Measure, a collection of essays. In that, in answering the concept of committed judiciary, Palkiwala said, and very aptly, a committed judiciary is a contradiction in terms. Either a man is a judge, if he is committed to any particular concept, he is predetermined, he ceases to be a judge. Just like asking for a pot of boiling ice cream. Today you may be getting a boiling ice cream, but in those days it was not there. So he said that this concept is a contradiction in terms. I think Mr. Subramaniam has elaborated this concept in individual ways. Now I will give you 2 examples. One is the example of Lord Atkins. In the University of Anderson, in the famous case where Lord Atkins gave his famous dissent. You see, it was a bench in which he was the lone voice of dissent. And when he gave the lone voice of dissent, those famous lines of his, that amidst clash of arms, Law is not silent. It speaks in one voice. The Lord Chief Justice of England requested Lord Atkins to omit certain passages from his opinion, because he said those passages contain a dose of ridicule. You can omit them. Lord Atkins refused to do so. Then you know what happened? The House of Lords, the other law lords, refused to eat with him. They eat together during lunch with us. They refused to speak to him. This is what happened to Lord Atkins. But his name is written in gold in the history of public freedom. Then with our country we have the example of great judge, Justice Khanna, in the ATM Jabalpur's case, where he said that a person has a right to go to court if an order of detention is wrongly passed against him, if an order is passed for vilified consideration, if he is passed wrongly, on the wrong identity. The other learned judges said, no, he cannot go. One of the judges went to the extent of saying, why should they go? They are kept in jail in motherly care and putting. Learned judges of Supreme Court, this 4-5 judge bench. Chief Justice Henry was already the Chief Justice. The other 3 judges, the senior most was Justice Khanna. The other 3 judges, Justice Payne, Justice Chandrachud, Justice Bhagavati, all agreed with Chief Justice Ray, and all later on became Chief Justice. Justice Khanna gave the dissent. And in his book, Neither Roses Nor Thorns, he has written, came back from the court and he was having tea, sharing tea with his wife and with his sister in the spacious lawns of the Supreme Court bungalow for judges. There he said, today I have delivered a judgment which will cost me my Chief Justice, and it did. He never became the Chief Justice of India. It was due to him. He was superseded. So this is the price of independence of the judiciary. This is the price which the bold spirits have paid. This is all matters of record. Justice Khanna said that right to life and liberty is not a repository of Article 21. By suspending Article 21, you cannot take from a man his right to life and liberty and his right not to be arrested.